Did you receive a notice of forfeiture? Or do you just want to know about forfeiture laws in Washington State or Seattle? If so, you've come to the right place. My name is Lance Fryrear, and I'm the Defender of Justice. Defender of Justice. Defender of Justice. Defender of Justice. I don't normally look like this. I look like this. And that's because I'm a defense attorney. And I have a law firm in Lynnwood, Washington. We've been defending people charged with crimes for more than 20 years. And we also handle forfeiture hearings. Actually, for 7 years, I was a prosecutor and I was on the other side of forfeiture hearings. So oftentimes we get called by people where the police have either seized somebody's car or their money or other property. It could be a boat. It could be many things. And it's very upsetting. And if you're in that situation or you're just curious, you may want to know what to do. Well, if so, I'm going to cover 3 things in this video. Number 1 is what property in general is subject to forfeiture in Washington State. Number 2, if you do receive a forfeiture notice if property is taken from you, what are the steps you should take right away? And then stay to the end for this, it's the most important. Number 3, what are some common defenses to forfeiture of property and how much you get your property back? Can you bargain for your property back? Well, I'm going to talk about that. So again, my name's Lance Fryrear. I'm the owner of the law office of Lance Fryrear. We've been doing this for more than 20 years. So if you find this useful, please like the video, please subscribe. It helps me get information out there. So forfeiture hearings, number 1. What property is subject to forfeiture potentially in Washington State? Well, the law basically says there is no property interest in any piece of property that's used in the commission or aids in the commission of a felony offense. There's also a separate line of forfeiture statutes that have to deal with drug money and proceeds from the drug trade. And that's another subject of forfeiture here in Washington State. But for the most part, it's property used in the commission of a felony or property used in the drug trade. And so the law states that the police, if they suspect that the property is being used illegally in that way in commission of a felony, they can seize it. And so number 2, if they seize the property, what is it that you need to do? Well, in most cases, they've either seized your car or they've seized money because I think it's drug proceeds. Perhaps they've seized other personal property. I've seen television seized. I've seen all types of things seized in the years I've been doing this. But what do you need to do? Well, they're going to serve you with a notice of intent to seek forfeiture of your property. So that's how you know if they're intending to forfeit it. Look at your paperwork. If they don't give you paperwork right away, watch the mail. They might send you the information in the mail that we're intending to forfeit your property. And this is the one situation that I'm really aware of in Washington State where you have a fair amount of time to make a claim on the property. Basically, you have 45 days from the date they serve you the intent to seek forfeiture of the property, 45 days to request a hearing. And you need to follow the instructions on the forfeiture notice. Usually you need to make a written claim stating what property you want to get back and why you want it back. How is it that you own it? And if you don't do that within 45 days, you lose your right to contest the forfeiture of your property. So it's really important you do that. So reach out to an attorney. You can text us at our business number, 425-670-9090. You can text us a copy of the forfeiture notice. Sometimes that helps try to figure it out for us. Or you can give us a call or any other attorney out there who does this type of work. So you need to request that hearing by following the instructions. So number 3, what are some common defenses to this? How might you get your property back? So thanks for sticking to the end. This is the important stuff. So once you request that hearing, the hearing is going to be set in front of a hearing examiner, not a real judge. It's someone who's usually appointed by the police department to hear these forfeiture hearings. So it's sort of a rigged game. You do have a period of time to try to remove the controversy to an actual court, typically to a district court where there's a real judge who will hear it, so it might be a little more fair, but it's difficult to do, so make sure you contact an attorney. But at the hearing, either it be by the hearing examiner or by a judge, they're going to take a look at the police reports for what the justification was for the seizure of the property. Why do they think it was drug money? Why do they think this car was used in the commission of a felony? That type of thing. And then you'll have a chance to say why that's not true. So, what are some common defenses? Well, one is an innocent owner. Let's say you're watching this and it's your son who was driving the car and got accused of some felony hit and run or something else. Well, if you had no reason to believe your property would be used in that manner, you can assert an innocent owner defense and try to get your property back, because you shouldn't lose your property if you're not culpable or you're not in the wrong. Additionally, another defense is, at least for property used in the commission of a felony, that unless you agree by settling, the government can't forfeit the property unless there's an underlying conviction of the felony. And sometimes felonies take a long time to charge, and you may not get convicted of the felony, so you may be able to get your property back that way. Additionally, if your property has a lien on it, let's say the bank has a loan on it, well, they're not going to, the bank isn't going to lose their property interest because, again, they're an innocent owner. They didn't know what was going on. So in that case, it's a chance you may not lose your property. Let's say they seized money. Well, maybe you have proof that that money you earned. Maybe you have proof that that was an unemployment check or someone just gave you the money. Oftentimes, officers will naturally think a large amount of money is drug proceeds. But if you have proof that that's not what it is, you can assert that and try to get your money back. Finally, and the most common way to get your property back, believe it or not, is you end up negotiating with the representative of the police. And what we call it is buying your own property back. But think about it this way. The police are doing their job and they think, hey, if this property was used in the commission of a felony, I can seize it. But it may not be worth that much to the police to try to keep it. This car of yours is 5 years old or 6 years old. The best case scenario, they're going to auction it. They're going to get some amount of money for it. It goes into the general fund, and it's a lot of cost to store and upkeep. And they're oftentimes they'll want to try to negotiate. This might go for guns. This might go for cars, and even, believe it or not, for money based upon risk. So the most common thing that happens is you or your attorney can try to negotiate a deal in the case. Now, if you have a slam dunk case, that might not be a great idea, but usually there's some gray. They took the property for a reason. And so it's best to try to see what your options are. So I hope you found this helpful. Again, you can like the video, you can subscribe. And if you have this type of problem, you can give our office a call. We've been doing this type of work on the defense side for 20 years, and I actually handle this type of stuff on the prosecution side for 7 years. So I know the ins and outs, and so does my team. So if you have this situation and you need some help, give us a text, give us a call. We'll do everything we can to advise you, and we'll be there for you. Thank you.